Have you ever been identified without your consent, just by walking down the street? In 2024 alone, police in England and Wales scanned about 4.7 million faces using live facial recognition technology. That's more than twice the number from the year before. And police vans equipped with this technology were deployed at least 256 times, up from just 63 the year prior. That means millions of people just going about their day, were swept up in automated scans that compare their face to police watch lists in real time. Now, that might sound like a useful crime-fighting tool, and to be clear, police say it's helped locate suspects and find missing people, but this raises huge questions about privacy, fairness and justice. What happens when technology replaces discretion? What if those scans are more likely to misidentify certain groups? Who gets to decide how the technology is used and under what rules? In today's roundtable discussion, we're exploring how artificial intelligence is entering the criminal justice system, the challenges and risks that come with it, and what action we can take.
Welcome to Spoken Injustice, where we put the criminal justice system in the dock. Today we are talking about something that affects all of us and is talked about in any environment nowadays: artificial intelligence. And in particular, how it's being used in the criminal justice system here in England and Wales. We'll break down where we are now, what the risks and debates are, and what we can do about it. So let's dive in. In August 2025, the UK government published an AI action plan for justice. This is a roadmap for using AI across courts, policing, prisons, probation services and tribunals. The plan aims to modernise justice services by using AI tools for things such as automated transcription and documents review, searching and classifying legal information quickly, scheduling and administrative tasks, tools to support decision-making in courts and prisons. The government says AI should support human judgment, not replace judges, lawyers or police. Fairness, accountability, transparency and bias mitigation should be built in. Governance and oversight structures will be strengthened. But here is the key. This is merely policy intention, not reality yet. It's important to be clear about one thing. AI in the UK justice system is not new. We have been using forms of AI quietly for over a decade. Legal research platforms like LexisNexis and Westlaw have relied on machine learning for years to rank cases, suggest precedents, and shape what lawyers and judges see first. Police have used the automatic number plate recognition and data-driven intelligence tools since the early 2010s, analysing patterns in movement and behaviour. Lawyers have long relied on AI-assisted e-disclosure tools to sift millions of documents in complex cases. And across probation and prisons, algorithmic risk assessments have informed supervision and parole decisions for years. What's changed now isn't the existence of AI. It's the scale, the speed and the influence of these systems. That's why the question today isn't should we use AI? It's how, where and under what safeguards. As I mentioned, we must remember that what's contained in the government action plan is merely policy intention. At present, there is no dedicated legislative framework governing this. It's also important to understand how the government sees AI fitting into the justice system, because it's often described as serving two different purposes at the same time. On one side, AI is promoted as a tool to detect and prevent crime and to support rehabilitation. That can include analysing patterns to identify crime hotspots, helping probation services assess what support an offender might need, or tailoring rehabilitation programs more effectively, or at least in theory. On the other side, AI is also framed as a way to strengthen justice itself, to enhance efficiency in the delivery of justice by providing access to legal information, speeding up case backlogs, assisting with evidence review, and helping courts run more efficiently. The idea is that if the system works better, people get fairer trials, delays are reduced, and innocent people are less likely to be harmed by procedural failures. These goals aren't automatically in conflict, but they do pull in different directions. Tools designed to predict risk or detect patterns can put pressure on individuals' rights, while tools designed to support fairness and access rely heavily on transparency and explainability, i.e. the ability to understand why and how a machine learning model makes a specific decision. Understanding that tension is key to understanding why AI in criminal justice needs careful oversight. So let's look into it in more detail. As we can see from the government's action plan, large language models, also known as LLMs, are being used. Now, LLMs are a specific type of generative AI. Their job is to understand and produce human language, things like text, summaries, and recommendations. But unlike other forms of AI, they don't think or reason on their own. They learn patterns from existing data. And that's where the concern comes in. As we know and as we have analysed through our videos, the justice system's historical data reflects decades of inequality and bias. If LLMs are trained on that data, they risk repeating and reinforcing those same patterns even when no one intends them to. For example, policing data that shows higher arrest rates in certain neighborhoods, or sentencing histories that correlate with socioeconomic disadvantage. If AI learns from that, it can reproduce and even amplify bias. So who is raising these issues? Amnesty International warns that predictive policing tools can be racist in practice.
There are two main ways the police are trying to predict crimes across the United Kingdom. One, by looking at you as an individual and how likely you are to commit a crime in the future. And two, looking at geographical areas and potentially labelling them as crime hotspots. In a new report, people spoke to Amnesty about being repeatedly targeted by police because of where they live.
Justice calls for standards and oversight to avoid an AI Wild West in policing and justice. Justice press release dated the 2nd of December 2025 states the use of AI by police could erode public trust and lead to miscarriages of justice unless the government establishes an independent body to set national standards, a new report has found. The report from law reform organisation Justice warns that England and Wales risk becoming an AI Wild West if 43 police forces continue to experiment without transparency, technical standards and legal clarity. The deployment of poorly designed AI can embed inaccuracy or discrimination in the process of investigation, leading to unjust outcomes. For example, AI facial recognition technologies have repeatedly been found to be less accurate for darker-skinned people and women, risking wrongful arrests. The report, which draws on evidence from countries around the world, urges the government to create a central body that can set national rules for the application of AI and help police forces innovate responsibly. It also calls for national legislation in areas like biometrics, rather than the current practice of individual forces writing their own rules for live facial recognition, which means people are treated differently depending on where they are. The speed of technological revolution and the government's push to use AI in public services leaves just a small window for urgent reform, the report concludes. And the Information Commissioner's Office, the ICO, has questioned the fairness and accuracy of facial recognition technologies used by police. In a statement released on the 5th of December 2025, Emily Keeney, Deputy Commissioner for the ICO, said last week we were made aware of a historical bias in the algorithm used by forces across the UK for retrospective facial recognition within the police national database. We acknowledge that measures are being taken to address this bias. However, it's disappointing that we had not previously been told about this, despite regular engagement with the Home Office and police bodies as part of our wider work to hold the government and the public sector to account on how data is being used in their services. While we appreciate the valuable role technology can play, public confidence in its use is paramount, and any perception of bias and discrimination can exacerbate mistrust. The ICO is here to support and assist the public sector to get this right. We have asked the Home Office for urgent clarity on this matter so we can assess the situation and consider our next steps. These aren't fringe voices. They are respected researchers and regulators. AI, especially large language models, can give outputs and look sensible, but are hard to explain. In a courtroom or police context, that's a major problem. Imagine a tool suggesting a bail decision, but no one can explain how it got there. That challenges not only legal fairness, but also accountability. Even when AI is meant to be advisory, people often treat it as authoritative. This is called the automation bias. Judges, lawyers, and police officers are humans. When a system looks professional and objective, there is a real risk it will be trusted even when it's wrong. And this isn't a theoretical concern. Last June, The Guardian reported that the UK High Court had urgently warned lawyers to stop misusing artificial intelligence after courts were presented with fake or fabricated case law citations generated by AI tools. The judiciary made clear that this kind of misuse risks undermining justice and public confidence, and has called for stricter professional responsibility, stronger safeguards, and clearer accountability when AI is used in legal work. Right now, there is no UK law specifically governing AI in criminal justice, and that's a concern. The government's plan talks about principles and governance, but principles alone don't guarantee outcomes. This is why researchers like those at the Oxford Institute of Technology and Justice are mapping AI use and calling for stronger frameworks. Fairness and accountability are not the only concerns. There are also concerns related to lack of transparency. According to the Review magazine's article dated the 18th of December 2025, what worries many observers is the lack of transparency. The Ministry of Justice has so far refused to publish detailed information about which systems are in use, who built them, and how they are tested for bias. Without that transparency, public trust in justice itself hangs in the balance. There is another issue we need to talk about, and this is actually not really about technology at all. Historically, the criminal justice system in England and Wales has often expanded powers or introduced new tools in response to crisis. Moments of public concerns, operational failure, or media pressure. We are seeing something similar now. News stories about prisoners being released in error, court backlogs, and overstretched probation services are being used to argue that manual systems are failing and that AI is the solution. The message is often, we can't afford human error, we need smarter automated systems. But this framing is dangerous if we don't stop and reflect, because we've been here before, haven't we? Take, for example, imprisonment for public protection, or IPPs. They were introduced in the name of public safety, based on predictions of future risks rather than proven harm. And now we know the result. Thousands of people held for years, longer than their original sentences, enormous human cost, and a system widely recognized as a failure. But only after the damage was done. If you haven't already, you can watch our video which breaks down these issues in more detail. I have linked it in the description below. The lesson from IPPs is not just about sentencing. It's about what happens when risk prediction is prioritized over rights and when urgency overrides scrutiny. AI risk tools, especially those designed to flag danger, predict behavior, or prevent rare but high-profile failures, can easily repeat this pattern if we are not careful. Technology can give decisions the appearance of objectivity while quietly embedding old bias and shifting responsibility away from human decision makers. That's why AI must never be introduced simply to compensate for political, staffing, or structural failures, especially in a justice system with a long history of risk-based injustice. So what can we do? Here are practical ways to stay informed and take actions. Educate ourselves. Read the AI Action Plan for Justice. It's public and it's linked in the video description below. Learn about organizations like Amnesty International, Justice, Liberty. Information Commissioner's Office, Oxford AI and Justice Research. These groups regularly publish accessible reports and explain what AI systems are doing in justice settings. Follow oversight developments. Keep an eye on ICO decisions about facial recognition, parliamentary review of AI and policing, legal guidance from the Law Society and the Bar Council. When regulations change, people often miss it until it's too late, so keep up with that. And ask questions locally. If your police force, local council or courts are piloting AI tools, ask them what system is being used. How is bias tested? Who audits it? Can you request explanation of decisions? Public pressure works, especially when agencies are required to justify their tech choices. And of course, join the conversation. Share this video, comment, discuss with your community, organize local meetups or online forums. AI in justice isn't just a tech issue. It's a social justice issue that affects fairness for everyone. AI can improve services, but only if it's used responsibly, transparently, and with strong checks on bias and fairness. Don't forget to like and share this video because this affects all of us. Join us again as we sit and rise in this unique trial.